Good afternoon and welcome to the Justice Center Summit session on the overview of the Surrogate Decision-Making Committee, or SDMC, as we like to call it here at the Justice Center. Now I'm going to turn it over to Vicki Klingon and Annette Kosenko from our SDMC program, and enjoy your webinar.
Thanks, Dava. So I'm Vicki Klingon. I'm the director of the Surrogate Decision Making Committee unit here at the Justice Center. I'm joined today with Annette Kosenko, who is one of our registered nurses and does reviews the cases that come through and does processing for them. We're happy to be here today to talk to you about Surrogate Decision Making Committee. Hopefully everybody can hear me well. If there's any issues, if you're having trouble hearing or following, or you have any questions, please put them in the chat and we'll be happy to help you with those. So with that said, I'm going to get started here. So we're going to start off right off the bat. You know my name, I'm Vicki Klingon. I have worked at the Justice Center since 2018. Before that, I was in disability advocacy work. So that's my background, and I'd like to know a little bit about yours. So we have a poll here to get a little bit more information about who I'm talking to, since I can't see any of you. So a poll's going to pop up just asking who you are. If you wouldn't mind answering the best available option here in our list, that would be really fantastic to know a little bit more about you. It'll help us too with some of the answers that we're giving and information here if we know who we're talking to. So please go ahead and share that. And while you're at it, if you want to toss into the chat, if you've ever used the SDMC program or are familiar with it, that would also be great to know. Just give people another minute or so to fill this in. I see some reactions. Oh, a panel volunteer. Thank you so much for coming. We really appreciate that you're here and seeing all these people who are some unfamiliar people and then other people who definitely are familiar with the program. Let's see our results here, see what we've got so far. Oh, a lot of provider agencies, and then some of the others that are showing up in the chat there, peer advocate, family member. These are really great. Thank you so much. I see an individual receiving services. Really great to see such a diverse pool of people. And hopefully I can tell you about SDMC and give you some information here that will help. So we'll go back to our program now and get started. So our agenda this afternoon is to talk a little bit about our program, what is SDMC, what do we do, and who is eligible for surrogate decision-making decisions. And we're going to move on from there to talk a little bit about how do you apply for an SDMC decision. And from there, we'll talk about hearings. And all of this will become clear in this next section when we talk about the program overview about what we're talking about with hearings and applications. But that's our general structure this afternoon. And so we'll jump right in. So the Surrogate Decision-Making Committee came about due to some background information. There were untimely court decisions that caused delays in healthcare. As we all understand, healthcare decisions usually need to be done in a timely manner. For people who couldn't make their own decisions and did not have a surrogate able to make decisions for them, going to court to get those decisions made sometimes took a while. In response to that, maybe people who didn't have capacity were allowed to decide for their own informed consent, even though they maybe weren't quite giving informed consent at that point. Or the emergency exception in public health law was used that allows two physicians to say, this is an emergency, we need to provide this procedure. Things became an emergency because they weren't being handled so timely. And looking at end-of-life care decisions for people with intellectual or developmental disabilities, those decisions literally could not be made for people who couldn't make their own decisions from birth. So in the 80s, we had a bunch of legislative hearings where they looked at all of these issues and talked through what was going on and how we could better help. So in 1985, the Surrogate Decision-Making Committee was established as a pilot program as an alternative to this court system. It was another way of getting things done. It worked pretty well. It was expanded statewide by 2001. And then in 2009, we were also given the authority to make some end-of-life care decisions, and that is just for people with intellectual disability or developmental disabilities. And essentially what the surrogate decision-making committee is we are a option for making decisions for non-emergency major medical and some end-of-life care. And we do so on behalf of qualifying people who do not have the capacity to make their own medical decisions and have no legally authorized decision maker. And as I said, it's an alternative to the court system. It's a method of getting people answers quicker than the court system really could. And it's a creative program in that it employs volunteer panel members to make those decisions. So it's not a court, you're not going to a courtroom. It's a quasi-judicial structure for this. So we're not in a courtroom, we don't have a judge, we don't have a jury. What we have is a panel of 4 volunteers who are trained to make decisions and talk to all the people involved and really get an idea of what it is that's going on and how they can help and what decision needs to be made. And the benefits of this program are, first of all, that it's free. So there's no cost to our program. Surrogate Decision Making Committee is free for anybody who qualifies and needs to apply for a decision. It's timely. We're pretty quick. We have, we can get to a hearing, get a decision usually within 10 business days. That's our overall goal. For some cases are expedited. The doctor says this needs to be made, a decision needs to be made on this really soon. We have to get this done. We can get a decision in those cases usually less than 5 business days. It's inclusive. We include the person who needs a decision made in our process. So they're the central piece of this puzzle, and we're not making any assumptions about them. They're at the hearing. They're going to be speaking up for themselves as much as is possible. We're encouraging them to be involved in all of these processes. And the process respects their legal rights. There are legally required pieces to this, including notification of hearing and sharing of all of the information that's been submitted for the decision. And that is for the person involved as well as any potential surrogates they might have. And the last piece of this is this process protects the autonomy of that person. So SDMC is not a guardianship program. We don't take over as the decision maker for everything. Decisions are brought to SDMC on a case-by-case basis. So we're really only making one decision for each of these requests, and it's for that particular procedure. So if somebody needs to have a colonoscopy and they can't give their own consent for that, SDMC can make that decision. But if next week they need to have a CT scan with contrast, they can't just use that same consent. They have to come back to SDMC to make that decision on the other procedure. We're not assuming that you can't make any decision. We're literally just looking at the one question in front of us and making a decision on that at that moment. So first of all, we have to find out who's eligible. And so this is for a person who already, we have to know they do not have capacity. If somebody has capacity to make their own medical decisions, that's great. They should make their own medical decisions. They don't need SDMC. If they likewise don't have capacity but have a surrogate, they also should be making their own decisions. So SDMC is not available for those people. They have a decision maker. But we are here for certain people who don't have capacity, don't have a surrogate, need major medical care, and are a current or former individual served by a program licensed, funded, or operated by the Office for People with Developmental Disabilities, the Office of Mental Health, or the Office of Addiction Services and Supports. Our end-of-life eligibility is a little bit different. As I mentioned before, that didn't come about until 2009. And the end-of-life care authority for SDMC is for people with a diagnosis of intellectual or developmental disability who also have an illness or injury for which there's no recovery and which reasonably will cause death within 1 year, permanent unconsciousness, or an ongoing medical condition with a requirement of life-sustaining care that will cause an extraordinary burden. So as you can see, there's sort of some safeguards built into this. It's a very specific role that we play. However, there is kind of a broad answers we can give. So just real quick, I just want to talk a little bit about informed consent. So when we say informed consent, there actually is a legal definition of that. And what we're looking for is there's been a full explanation of the proposed procedure, including a description of risks and benefits. There's been information about the level of discomfort and the effect on functioning that this procedure might give, and a disclosure of any alternative procedures. And for informed consent to take place, we have to have knowledge that that consent is voluntary and that person also has the right to withdraw their consent at any time. A lot of these pieces go into the SDMC decision-making in general. The panel also is going to be looking at these explanations, the description of risks and benefits, discomfort, functioning, any other alternative procedures. So the Surrogate Decision-Making Committee is authorized to make certain major medical decisions, and that includes medical, surgical, dental, or diagnostic interventions or procedures that include the use of general anesthesia, significant invasion of bodily integrity, significant risk, chemotherapy, hospice, or any treatment or procedures with informed consent required by law. These are all outlined in Mental Hygiene Law, Article 80. That's our statute that authorizes the Surrogate Decision-Making Committee program. There are treatment and procedures with informed consent required by law. That there is a law that says that these above procedures are those procedures that do require informed consent. If a law was passed tomorrow that said informed consent is required for any given procedure, that would authorize SDMC to make those decisions as well. And there are some exceptions to what we are allowed to make decisions on. So there are exclusions in the mental hygiene law, and that includes routine diagnostics, treatment, or medication administration. You don't have to come to SDMC to get a decision on a prescription that the doctor has just requested that you take, or just to get blood work done. Those are routine. They're, not a major medical request. Dental care performed under a local anesthetic, same thing. There's not an extra risk there. It's accepted that you can get dental care performed under a local anesthetic without having to come to SDMC. Emergency medical treatment. As I mentioned before, there's an option under public health law for if you're in an emergent situation that medical providers can help you. Electroconvulsive treatment, sterilization or termination of pregnancy, and withdrawal or discontinuation of life-sustaining treatment, except as provided in the Healthcare Decisions Act, are all excluded from SDMC. We don't make decisions on ECT or sterilization, and we are very limited in what withdrawal or discontinuation of life-sustaining treatment we can provide. The Healthcare Decisions Act is the name of the law that passed in 2009 that gave SDMC the ability to make those decisions. So it's just, as I said before, just for people with a diagnosis of intellectual or developmental disability. And for major medical, we also have the ability to help people who are, say, served by the Office of Mental Health. So they might not have those same diagnoses, and we can only assist with mental health, people who are in the mental health system for major medical and not with end of life. So end of life requests, this is outlined, as I said, in the Healthcare Decisions Act, which is in Surrogate Court Procedure Law, Article 17A, Section 1750B. And it authorizes SDMC to make decisions for the withdrawal or withholding of life-sustaining treatment for persons with an intellectual or developmental disability. And what that includes are things like a do not resuscitate order, do not intubate order, any restrictions on artificial nutrition and hydration, the use of antibiotics, vasopressors, chemotherapy, blood transfusion. We do also authorize comfort care with hospice services or any other treatment that the physician deems life-sustaining. So for instance, if someone was on dialysis and they're coming towards the end of their life and the doctor wants to say withhold dialysis, that would be one of those specific to the person items that we could do. Looks like Davin has popped up with a question.
I do. I have just a couple of questions. Someone wanted to know if there's a generic informed consent document that can be shared.
That just explains informed consent. I don't know exactly. I'm not actually sure. That is a great question. I don't know the answer to it. So there could be something out there. I'm not really sure. I would actually think that there's something, probably the medical professions would have something that really easily spelled that out.
And you can always call us and we can talk through that with you. And then just who typically seeks SDMC, input or seeks this? Is it the group home or the medical provider? Who's reaching out?
That is a great question. It's all of the above. It can be anyone involved in that person's life. It could even be, there can be a surrogate who just is not able to make this decision or just doesn't feel comfortable making this decision. There's nothing that says a surrogate can't be the one who brings SDMC a request. And that's going to get into that in the next section a little bit about who brings these questions in and who's involved in that process. But really, SDMC, the program authorizes anyone who's involved and has the answers to bring a request.
And we did get a comment in the chat that said each medical practitioner would have their own informed consent document that you could get. And that person also said that they had a great experience working with SDMC.
Oh, great. Thank you. Thank you. Really helpful. Please keep the questions coming. Just got a quick poll here. We can pop that up, just see if you're following along with what we've been saying here. There we go. So which of the following is not a major medical procedure requiring informed consent? A, open heart surgery, B, chemotherapy, C, dental exams and fillings under general anesthesia, or D, a blood draw or lab work. So just a quick question about sort of what we've been talking about here, because it can be confusing and it's nice to talk it through a little bit more, give people a chance to answer that. If it looks like we have a lot of answers, we can go ahead and get the answers or leave it open a couple more minutes. Okay, so actually the answer here for not a major medical procedure requiring informed consent is D, blood work or blood drawn or lab work. It's routine. So that's a routine procedure, does not require SDMC consent. You can go ahead and do that with consent any other way. The other items on the list are more, risk. Usually I like to think of it as like a more risky procedure. The law says invasion of bodily integrity, which is very like wordy and legalese language. I think it just means sutures. So anything that might involve sutures, surgery, chemotherapy requires a lot of somewhat dangerous chemicals and things like that, kind of a more risky procedure. Anything with lots of risks, including general anesthesia. Those are the things that would come to SDMC that hit that level. If you're ever not sure, if you're serving somebody or working with someone who needs to give consent for a procedure and you don't know, give us a call. We're happy to help. You'll get our number at the end of this presentation. We get those questions all the time and we love to answer them. So please give us a call. We'll help you sort through what it is that you're trying to get consent for.
Hey, I have one quick question, and
Sure.
I know it's one that comes up. Does SDMC provide consent for medications prescribed for behavioral purposes if the person can't consent?
We do not do that. That's your MIPS program that you would go to in the provider agency. So SDMC does the medical part of it, the behavioral things and restraints and things like that come through the other program. And there can be a little overlap sometimes with dental work, especially. So we do work together with them if there's something that needs, we need to kind of coordinate. We're happy to hear what they've offered and what we can connect with. So that was also a great question. I'm going to turn things over to Annette Kosenko now to talk through the application process.
Hi, everyone. My name's Annette Kosenko. A little background. I've been a nurse, registered nurse for over 30 years, and I've been with SDMC for almost 8 years now. So we're going to move on and talk about the application process. Certainly, you can give us a call if you have questions about the application or how to get information. We do have a QR code on this screen that if you screen that or scan that, excuse me, you will get right to our page. We're under advocacy and support on the Justice Center website, and there's a lot of great information on there. We have our forms listed on there, our 200 series for major medical and our 300 series for end-of-life care decisions. What's great about that is if you go to that page and you download download the applications. They're fillable forms, so you can fill them in online, save them to your computer, and then when you have everything, you can send it to us. And I have to say, we love that because then we can read everything very clearly. So when you're working with providers, you can let them know that they are available online if they would like to fill them out online. That would be great. There's a lot of resources on our page, and we'll talk about that as we go through the program. So the declarant, a lot of people ask, what's a declarant? Who's the declarant? And this is a person who submits the entire case. For each of our series, the 200 or 300, there's 4 sets of forms. So that person is like the keeper of the case, I want to say. They submit the case to us. Usually it's via email or fax. And anyone can be the declarant. Typically, what we see is it's usually the registered nurse who covers that person for the agency, for the home. It could be the director, the residential manager, could be a relative, it could be a provider. And then it's someone who should be familiar with the person, kind of on a daily basis. You know, can they feed themselves? Can they make decisions for themselves? Do they choose, what they want to eat or where they want to go? It's important to know their family status. Is family involved? Does a brother or a sister come by and see them on a regular basis? Or do they send cards? Do they call periodically? How involved are they? Are they involved in their meetings? Do they want to help make decisions for the person or not? And of course, the declarant should know what their medical needs are. So for our major medical requests, that's our 200 series. The 200 form is completed by the declarant. That has a lot of information about the person, where they live, who the house manager is, the nurse, who their care manager is. And going back, a care manager is another person who may submit a case for a person. And it also lists any possible surrogates, if there is anyone involved that may be able to sign for them. And also any correspondence, might be friends, people who come and visit periodically, take them out for lunch. But any questions on anything when you're filling out the paperwork, give us a call and we can help you out with that. The capacity is our 210 form, and that needs to be completed by a licensed psychologist or a psychiatrist. This will determine if the person is able to consent or not for themselves for the specific treatment that is requested. The certificate of medical need is our 220A, and that needs to be completed by a licensed physician. And that will tell us what the request is. It asks questions about the need for it, the side effects, what type of anesthesia that might be used, and other questions on that form. The related medical information is the 220B, and this can be completed by the declarant, the nurse, or the care provider. This will ask for information about their most recent physical, maybe some lab work. And what's most important also is that, for instance, if a physician is requesting a colonoscopy, of course, we're going to want that GI consult that says the patient is having symptoms, they need to have a colonoscopy, or perhaps it's a routine, they're just due every 5 years, 10 years, whatever it may be. So we need to have that consult. Our end-of-life care forms are the 300 series. And once again, the 300 is completed by the declarant. Our same information that we would get from the 200. The 310 is completed by 2 physicians, or a physician and a licensed psychologist. And on the next slide, we'll get into that a little bit more. There's a little bit difference here between the 210 and the 310. Now, the 320A is the request. And that's, I believe it's a 5-page request. And that has all the information on it that we need in order to process the case. And that needs to be completed by 2 physicians. The attending and concurring, they have to be in agreement for this form. The 330 is, again, the medical information, related medical information, their last physical. For the most part, we get our end-of-life care decisions while the patient is in the hospital. Sometimes they're at home. So when they're in the hospital, typically we want to be sure that there is some kind of consult, maybe from palliative care, or some kind of consultation that says this person is ready for end-of-life care decisions and this is why. So that's important to have that along with this form 330. So here we're going to talk about the 310. We do need 2 practitioners for this. Excuse me. And one of the practitioners must meet one of this criteria. Be employed by a developmental disability services office, have been employed for a minimum of 2 years to render care and services in a program run by OPWDD, or be approved by the commissioner of OPWDD.
Can I jump in and give you a break in it?
Yeah, sorry.
Sure. That's totally fine. Yeah, no problem. So yeah, the mental hygiene law is a little bit different from the surrogate court procedure law here. So there are a little bit more, an extra step that we need for capacity determination for end of life care. And it does include this extra step with somebody who is familiar with people who have developmental disabilities in some way, and these are the requirements under that. So that's where that comes from.
Thank you.
Yeah, I'll do the next slide. I'll just do a couple of these for you. I just went ahead. So the next part, just talking a little bit more about the 320AB. As Annette said, it's the attending and the concurring physician. We need 2 physicians for these, just 1 physician for the major medical requests. But they do have to certify that there is a terminal condition, permanent unconsciousness, or a requirement for life-sustaining treatment that's irreversible and will continue indefinitely. And that makes this a little bit more restrictive than just the general end-of-life care requests for, that people might be putting out. You might be making your own decisions. For people who have developmental disability or an intellectual disability, they need to already be near the end of life for these decisions to be made. And there's also a clause that says that the qualifying condition cannot be that intellectual or developmental disability. We don't usually see that, but I think that was a concern when they wrote the law, that there might be someone being a little bit flippant. They wanted to make sure that it was really clear that somebody knew about this population, was really being understanding of what capacity means to somebody with an ID or a DD, and also that they were paying attention to the needs of that individual related to the terminal condition. And that, just let me know when you want to come back in here. I can do these next couple. So physicians also certify that there's an extraordinary burden for that continued life-sustaining treatment. This is another extra step too, where in addition to having that qualifying condition, we also need to show that there is an extraordinary burden of providing that life-sustaining treatment. So we look at the person's medical condition, other than the ID and DD, the impact of the life-sustaining treatment on their quality of life, the degree of pain, for instance, that they might experience with or without treatment, and also the person's chance of recovery, as well as risks and benefits associated with continued treatment. So it's really looking at those best interest considerations, and looking at what it is about that life-sustaining treatment that provides that extraordinary burden, that makes it actually burdensome to keep providing this for that person. And those are the basic rules for how we're making a decision and about whether or not someone will continue to get life-sustaining treatment. In addition, we're looking separately at artificial nutrition and hydration. So if there's a request that includes withdrawal or withholding of artificially provided nutrition or hydration, the two physicians must also agree that there's no reasonable hope of maintaining life, or that that artificially provided nutrition and hydration poses another extraordinary burden. So these are just sort of itemized pieces of that end of life care request that we have to point out separately. People see these on the application and they're not sure where they come from. So we wanted to make sure that we really clearly articulate that these are separate considerations written within that law, and that they have a real purpose. They really allow us to look through how it is that this person is living and what are these issues, and how can we best provide care for them. Comfort care. Comfort care is one where there's sometimes a little bit of confusion. So we like to talk a little bit extra about comfort care. Comfort care is medical care and treatment that's provided to relieve pain and reduce suffering, but it does not include any further withholding or withdrawal of life-sustaining treatment beyond what is explicitly written in the SDMC consent. So sometimes when people are talking about end-of-life care in general, they use the term comfort care, doctors included. They say comfort care and they mean we're not going to provide anything other than what makes that person comfortable. So they might actually be saying withholding or withdrawing life-sustaining treatment. For this population, in order to have everything, by the book and written out clearly about what services we are providing and what care we're not providing, if there's something that actually is withholding or withdrawal of life-sustaining treatment, that actually has to be requested of SDMC and provided on our consent in order for it to be implemented in that person's life. So for instance, if we said, somebody said comfort care and they really also wanted to make sure, I'll go back to my earlier example of dialysis, that we're not continuing to take that person for weekly dialysis because we're trying to make them comfortable at this point. They need to say, we're not going to take them for dialysis. Otherwise, the process of getting those orders approved is not going to work. So we just want to make sure that that's part of the application. If you're not sure, if you're actually filling out an application and you're not sure about this might be something that you give us a call about, because we'd be happy to walk you through what needs to be written on that consent and whether or not you're asking for everything that you really need to be asking for on that application.
Thank you, Vicky, and I apologize for that. But like Vicky said, certainly give us a call, because sometimes when we review the end of life care decisions, we read through the case, we read through the chart that we get, and we may say, hey, maybe you need to ask the doctor if they want to add this, or are they going to continue this, or are they not going to continue this? And things can change very quickly when it comes to end of life care decisions. We get a case in, and within a day or two, they can, become more acutely ill, or things can change. And we always say to give us a call and let us know what's going on. But certainly call us ahead of time if you have any further questions regarding the request.
Annette and Vicki, a couple questions have come in before we go on. The first is, in the case of someone needing dental care under general anesthesia, is it okay if the dentist completes the certification? That qualifies as a
Yes,
doctor.
absolutely.
Yes.
We usually say that dentist, podiatrist, as long as they're a medical doctor. Yeah.
Mm-hmm.
And what role can SDMC play if a person is declining a recommended treatment?
That is much more complicated. Depending on, so for people who are served by the Office of Mental Health and refusing treatment, SDMC can't make the decision over their objection. If it's someone who has an ID or a DD and maybe just doesn't fully understand, there's a possibility that we could, provide consent over their, saying they don't want it, but we don't provide consent that allows you to do something over their actual imminent objection. So if somebody's they just won't go out the house, they refuse to go to that appointment. An SDMC consent doesn't mean that you have, the ability to just make them do it. They do get to make that call on their own. It's just, sorry, it's tricky. It makes things really difficult sometimes for providers. I know it's really hard. We know that you do your best, but we would tell you to try to talk to them and maybe talk them into it or talk them through whatever it is that they're concerned about, but we can't really do things against their will.
And you may or may not be able to answer this because it's about an OPWDD form, but why does the OPWDD MIPS form have a box for general anesthesia dental if you have to go to SDMC rather than the informed consent committee for general anesthesia?
That's a good question. We don't have a role with the OPWDD form makers, but I do know that they just updated their memo on the MIPS form to very clearly clarify that SDMC makes the decision on the general anesthesia piece of it. So yeah, that form might be a little confusing, and I encourage you to talk to some of the nursing staff and people who make that decision at OPWDD and report that higher. But yeah, we definitely do come to SDMC for the general anesthesia piece.
And for those who don't know what a MIPS form is, could we spell out that acronym? And then I'm going to disappear now.
Annette, can you do it?
Oh, no.
I think it's medical intervention. Sorry.
It's been a long time since I've seen one.
I'm not exactly sure what it is an acronym for, and someone please chime in the chat if you do know what the acronym is for. It's about interventions that require restraint.
Right.
Sorry, you're really putting our knowledge on the spot for this afternoon. Hopefully somebody in this program can share that in the chat.
Okay, so
they did. It's medical immobilization protective stabilization. That is a mouthful.
wow.
Several people
Okay.
have chimed in.
Thank you so much.
Thank you. So in a nutshell, our process is the declaration is submitted. One of the SDMC nurses processes the case. Then a hearing is scheduled, hearing is held, and then the decision is issued. And now we have a poll. Okay, to apply for an SDMC decision, you must hire an attorney, pay a court fee, complete the 4 SDMC declaration forms, go before a judge. Okay, let's see what our results are here. Yes. C is the correct answer. Complete the 4 SDMC declaration forms. Wonderful.
We're back to the SDMC process now. It's not as cute as that video was, but I hope that you're all still with us and enjoyed that little break. Allowed us to get a little drink of water and stretch. So we're going to talk a little bit now about the hearing process, and we just ended on Annette's slide that sort of walked you through how a case comes through SDMC and where it goes. Our hearings are actually organized by our regional contractors. So someone in your region will be the one who actually organizes the hearing, schedules it, make sure everybody has the right time and can attend together. So that's who would reach out past when we get to the hearing point. And some main things about the hearing: the person who needs a decision must attend. That's especially true for a major medical decision. If someone has a medical issue or it's, an end of life decision, they're in the hospital, they're really not doing well, we have a little bit of leeway where we can visit them if needed. But we really do want them there. We want them to be a part of the entire hearing. We want to hear from them, learn a little bit about them, and you really don't get that other than having a face-to-face interaction. We do currently hold hearings by video conference. They used to be held in person in a convenient location for that person. So if they were home, we went to their house, did it around the kitchen table, went to day program, did it in a space there. Right now we do it by video conference. So we just ask that the providers who are working with that person bring them to a private area, set up the camera, have everything ready to go, and help them through that process of understanding who they're talking to and better, interacting with us. Every hearing is recorded. As I said before, this is a quasi-judicial procedure. So we do record the hearing. There is an official record of it. The declaration is part of that record. Care providers, everybody who's going to speak at the hearing is sworn in. So you are under oath. And what you're providing is called testimony. We try to make this as friendly as possible, even though those are sort of intimidating words. But you're really just speaking up as to what was requested and what this person's life is like and helping advocate for them. And at the hearing, so we have our panel of 4 people. They're the ones who are going to ask the questions. There's a chairperson who will sort of lead through things. There's an opening statement. They kind of set the stage to what's going to happen. They're going to look at 3 different decisions, and they're going to look at them in this order. And the first question is capacity. So does this person have the capacity to understand their risks, benefits, and alternatives to this medical procedure? Then they're going to move on to the legally authorized surrogate. Is there a legally authorized, willing, and available surrogate who can make this decision? And the third question is this procedure in the best interests of this person? So when we look at capacity, the panel is really looking to understand whether that person lacks the ability to consent to or refuse major medical treatment. And that looks like when they cannot understand the proposed medical treatment, or they can't understand the risks, benefits, and alternatives, or they're unable to make an informed decision about that proposed treatment in a knowing and voluntary manner. The panel is going to ask questions directly of this person. They're going to talk to them a little bit. Some of it might just be, a little bit of banter to just get a discussion going with them, just to really get an idea of what it is that they do, what they like, what they make decisions about in their daily lives. We do have, as part of the declaration, a certification on capacity from a psychiatrist or psychologist that says, well, this person can't make these decisions, but we want to know, like, the panel really wants to get into it a little bit with that person. So do they really not understand that treatment? What is it about the risks and benefits that they're not grasping? And sometimes the panel might say, I think they do understand what they're saying here and that they should be making their own decision. And it's up to the panel to make that decision. So capacity is our first question. The panel can deliberate and say, we think they have capacity. We're not going to go any further. If the panel decides a person has capacity, they do not move on any further than that. They're going to look at these. That's why they look at them in that specific order, because SDMC does not have the authority if a person has capacity. So the panel will look at that and will move on appropriately. They also, a panel of 4 people, 3 people have to make the same decision. If they cannot come to a decision, it's assumed that that person has capacity. So if someone does not have capacity, the panel thinks that they agree there's no capacity there. We need to then look and see, is there a surrogate? So that's a person legally authorized to do so, to make that decision, as well as available and willing. So for someone who's coming to for a major medical decision, mental hygiene law, Article 80, identifies a parent, spouse, adult child, or a court of competent jurisdiction as the surrogates. So if they have a court-appointed guardian who makes medical decisions, then SDMC is not making this decision. There's a surrogate. Same as if there's a parent able to make those decisions. We go right ahead and do that. If the person is served by OPWDD, however, and there's not someone in that list, we do look at this hierarchy. So the OPWDD regulations outline a hierarchy of people who can make decisions, and these are also the list that we look at for someone who's coming to SDMC. So that's only for people served by OPWDD, though. That's not for people served by OMH or OASIS. And this one's a hierarchy, so we are at the end. So basically, if there's a surrogate, SDMC is not the right place to come. But if there's anybody on this list who's actively involved in someone's life, wants to make that decision, they should be the ones making that decision. Daphne, you have a question?
I do. Well, I don't, but so this person wants clarification. So the panel can determine that a person has capacity to make a decision, even if the provider has completed a psychiatric evaluation or a psychological evaluation and capacity assessment and determined that they are unable to?
Yes. Yeah, the panel gets the last word on this. So, they don't typically just go against it, but there are sometimes situations where maybe that capacity evaluation doesn't really get into the real detail. They're having a conversation with that person and they think they get it, and sometimes they really do. So yes, the panel can say, we think that they have the capacity to make this decision.
Thank you.
Yeah, no problem. Surrogates can be a little confusing sometimes, but it's just important to know that there is a place to review who's legally authorized. Because there are certain situations where people, so like a foster sibling, might be actively involved, but is not on this list of surrogates, so they can't make the decisions for that person. And I know Annette already mentioned correspondence a little bit earlier, but it's always worth going into a little bit more. Our forms identify who's a legally authorized surrogate, or a potential surrogate, because we want to know who those people are, because otherwise it's very confusing at a hearing if it comes up. A surrogate is different from a correspondent. There's also a section for correspondents, and correspondents are not legally authorized to make the decision on someone's behalf. That's what the difference between the two roles. But they are involved in that person's life. So they have a genuine interest in promoting that person's best interests. That's the way it's written in the law. They have a personal relationship with them. They participate in their care and treatment. They usually regularly visit or communicate with them. This could be friends in the community. It could be someone served in family care. The family care provider is with them all the time, takes them to appointments, but they're not their decision maker. Community advocates we see in this role a lot, or just friends. So it's always important to kind of note that it can be confusing because we are using legal terminology, but once again, if you put someone in the wrong place, the nurse will work it through with you and have a discussion with you about who that person is and whether they are a correspondent or a surrogate. Just Dan's got a question.
Yep, just I think quick clarification. So a surrogate is just an actively involved family member, not just any family member.
If they are served by OPWDD, active involvement comes in, and if it's end of life care, it's only the actively involved people. If it's someone served by OPWDD, or if it's just a major medical request, it does include parent, adult child, spouse, or a guardian. So those people are included in there. So it can be, we are legally obligated to notify a parent, adult child, or spouse that there's a request, whether or not they're actively involved in that person's life. So that can be a little confusing, but typically that OPWDD list is really handy when you're having a situation where a hospital or a person who doesn't know this system, doesn't understand these surrogate roles. It's really helpful to be able to point to that and say, no, this person is legally authorized to make these decisions. This is on the list of people. So that's a handy one to point out. And we also, if you send us a case, or if you say the doctor says they can't take the cousin's decision, even though they're actively involved and they've been making these decisions for years, we will also say the same thing as you're saying. So we'll help you out with that as well. We don't usually need to take that to a hearing for a panel to say, yep, this is a surrogate. We can verify that for you too. You can have us say, sorry, we can't take this case because there is a surrogate here.
Okay, and then just one thing, can the foster sibling, they're not seen as a surrogate, they're just correspondents, or?
They are, so within our process, yeah, they're not, foster siblings are not a legally authorized surrogate under New York state law. But they could very well be involved in that person's life. I mean, their family. So we encourage you, if you're setting an application to SDMC and there's somebody involved in their life, to let them know they can be a correspondent. And even if they don't meet that level of correspondent, if the person who needs a decision has someone that they like involved in their life and they want them to come to the hearing, SDMC is always willing to include them. We want to have as many people there as can support that person.
And one last question before I stop interrupting you. So if someone has involved, a spouse or a child, but they also have a healthcare proxy, who makes that decision? The healthcare proxy or the family?
That's a good question, and I think you should probably consult your attorney on that one, because I don't know which one would be the best one there. So all I can say is if there's actively involved family and a healthcare proxy, then SDMC is probably not the decision maker in that situation.
Thank you.
No problem. Please keep the questions coming. These are great questions. And the emojis popping up too are really fantastic. Thank you. So our third question, we're at the hearing. The panel does not think the person has capacity to make their own decision. There is no actively there's no legally authorized, available and willing surrogate. They then move on to the question of best interests. And when we look at best interests, we train the panel members to look at what's going on and is it promoting the personal well-being of the person? And we look at the risks, benefits, alternatives of a proposed major medical treatment, taking into account that relief of suffering, preservation of restoration, or restoration of functioning. Is this actually going to make that person better? Where is it going to stop some sort of debilitating process? Is it going to improve their quality of life? What's the quality of life going to be with and without that treatment? And are there any beliefs or values held by that person? So back to capacity, if we don't think that person has capacity, they still might have some insight onto whether or not they want this procedure. And that's valid and important and goes into best interests. Here, oh, this is very important too. This is the list of who is at the hearing. So we're going to have a hearing. It's, it's small in that it's not a huge amount of people, but there is still a good chunk of people who are there. We have the person who needs decisions made for them. We have our 4 panel members. The person who is the declarant who actually submitted the paperwork is always there. We also encourage any providers who know about that person's life. Could be the care manager, could be the nurse at the house, maybe a social worker at the hospital, any of their doctors who might be relevant to the discussion. We have any surrogates and correspondents. Our local SDMC representative is going to be there. They administer the hearing. The panel members lead the hearing, ask the questions. The representative is there to make sure that it follows the SDMC process. And then we also have a representative of mental hygiene legal service there. And that is the representative of the person who needs decisions made. They're making sure that their civil rights are respected. In many cases, this is an attorney. So they're making sure that that person, that the full process under the law has been followed. They're going to voice any objections to any piece of this. They also have the right to object to SDMC making the decision on behalf of that person. So the person who needs a decision made can always object to SDMC making that decision, and then we cannot make that decision. That would stop the process and they would need to go to court to make a decision. Mental hygiene legal service provides that representation at the hearing. And that brings us to I think this is our last poll. So if you want to pop that up on the screen, we're just going to really quickly talk about what's true about an SDMC hearing. An individual in need of a decision must attend the hearing. Any legally authorized surrogate and/or correspondent will receive notice of the SDMC hearing. Participants should be prepared to testify, or D, all of the above. Go ahead and answer that question. If you have any questions about any of these slides, please stick those in the chat. Now's a good time to do that so you're not missing anything. I'll take a drink. All right, let's see what we've got here in our poll results. And pretty much everybody here's got it. It's all of the above. They were all correct. So we do always want that person there, and we're sending out a notice of hearing to any authorized surrogates or correspondents, and anyone who's participating should be prepared to testify. Now I'm going to hand it back to Annette to talk a little bit about our consents.
Okay, so our major medical consents are valid.
Annette, your video's not on.
There we go. I'm back. So our major medical consents, our consents are valid for 60 to 365 days. And that's just determined on the procedure, how much time you might need. Sometimes there's scheduling issues, and sometimes treatment needs to be done more than once. Sometimes someone may have a colonoscopy and they have a history of a bad prep, so they may need to have it again that year. So work with the nurse that has the case to help you determine what would be the best time frame for that. The consents are not issued to a specific healthcare provider, meaning that the consents are specific to the person and the actual procedure that's being done. Any provider that is qualified to do that procedure can do it, and it can be done in any facility, obviously, that can do that procedure. So it is specific to the person and the procedure. Additional consents are not required. Our consents are legal and valid consents. We do not sign consents from, from a doctor's office or from a surgical facility. Our consents are legal. They're not specific to the type of anesthesia. So it's up to the physician, the anesthesiologist, to determine what type of anesthesia needs to be used in order to do that procedure safely for the patient. So if a patient needs a procedure and say they're going to use IV or MAC, and then they decide they need to use general, that could happen. It's covered under the consent. And it also allows the physician to move forward with any related procedures. So if someone has a procedure done and maybe they need a CT scan to determine if there's anything else going on related to that procedure that was granted, consent was granted for, they could use that as a related procedure. And you'll see this information right on the second page of our consents under the actual procedure. There is a paragraph that states this information. And if you have questions about that, give us a call if it's related or not. And typically we'll look at it and we'll say, well, does the doctor feel it's related? Or sometimes a physician may call us and ask us about that. But once again, give us a call and we'll help you out with that. For our end of life care decisions, the decision is issued in writing. We are listed as the decision maker and there's no expiration date. Now, for end of life care decisions, the person needs to continue to meet the criteria for the request, and that's done by the medical physician that's following the patient. And that's what is required by law. When our orders are consented for end of life care decisions, the next step would be to have the most checklist completed for people with intellectual and disabilities. The decision is made, it's completed, the checklist is completed, which is notification. It ensures that the Healthcare Decision Act process was followed, and it should be attached to the MOLST checklist. For the MOLST and SDMC, we do not, there is no option for a trial period. The life-sustaining treatment to be withheld or withdrawn must be identified by the physician. And this goes back to our 320AB forms, where it needs to be identified on that form. And some decisions may be deferred, like artificial nutrition and hydration. Hospice admission, we do consent for hospice admission. Typically, we do it with our 300 series end of life requests, but it could also be requested through our 200 series major medical. Admission form, there's a lot of hospice agencies throughout New York State, and a lot of their consent forms can be different. So we usually ask them that you send us their consents. And we do sign off on, we can sign off, or a provider agency can sign off for admission and receipt of rights. Any payment authorization and selection of a doctor should be completed by an authorized person from the residential provider agency, not SDMC. So we wouldn't sign off on payment authorization. And typically we work right with the hospice agencies directly so that we can get the consent signed off so that the person can get those services in place.
I have a quick question for you, Annette.
Sure.
Or Vicky. If a family has 17A guardianship, do they have to go through SDMC for end of life decisions?
No, they can make that decision.
Thank you.
You're welcome. And that question does come up sometimes, so really give us a call and we'll help you out with those questions that come up if you're unsure. If you'd like to become a SDMC volunteer, you could visit our webpage and the volunteer now. If you click on that tab, it'll bring you to information about how to become a volunteer. Has a lot of great resources there. We have our volunteers, it's what makes our program work. We couldn't do it without them. So it's very important. If you're interested in being a volunteer, give us a call. We have a coordinator here who could speak with you, or go to the site and take a look at what we have there. Some other resources on the site. We have a mock hearing video. Kind of goes through how a hearing takes place, different dynamics of the hearing, who's there. We have the volunteer handbook. We have sample forms, guidance documents, and webinar trainings. And like I said, we have the fillable forms on there too. So I encourage you to go in, download them to your computer and fill them out that way. If you have questions, give us a call about eligibility, forms, consent, any related procedures. It's important that providers be prepared for testimony at hearing. Typically, we really try to talk with you ahead of time to make sure you're prepared for the hearing. And if you have questions, you have our contact information. If something comes up before the hearing, give us a call. We'll help you through it. And if you'd like to become a volunteer, reach out, and we have that volunteer email you can also send an email to.
We have one question again about the 17A guardian. I think the person just missed it. So if they have a 17A guardian, they live in OPWDD licensed home, does a checklist still need to be submitted for end of life?
I think so, yeah. But
Yes.
I think we would, have them ask the provider agency for assistance.
Right, so it wouldn't go through
Pretty
SDMC.
sure.
Right?
It's not SDMC.
Right.
Here's a question. Over a decade or more, an individual has had several colonoscopies. If it's the same procedure over and over again, why do we have to go back every time to SDMC?
I would love
Well,
that.
we can both answer that maybe.
Yeah, go ahead, Annette.
Well, I'll start. I mean, because things change with a person, their medical conditions can change, and we want to look at what's happening with them right now. Right now they need a colonoscopy. Yeah, maybe they had one last year or 5 years ago. Why would they need another one? Or why do we have to keep coming to you when maybe they're preventative and routine every 5 years? Why do we have to? Well, because things can change in your health status, and we want to ensure that that patient is going to have that treatment safely. We want to be sure that they can have it, and we've looked at all their medical conditions and make sure that there's no other possible surrogates that could consent for them. There's a lot of things in our process that we look at to ensure that the patient gets what they need.
Thank you.
That was a great answer. I will just add that capacity can also change over time.
Yes, exactly.
And like I said in the beginning, the program is really set up so that we're looking at that specific question before the panel. So each time we're looking at them for capacity. So there's a chance that somebody maybe after 2 colonoscopies actually better understands a colonoscopy. But maybe the psychiatrist or psychologist, kind of also is going on that road, like they don't understand these procedures kind of thing. But there are risks for colonoscopy, so we do want to make sure that that is a major medical procedure for a reason, even though it's routine. But yeah, same thing. We want to make sure that capacity, surrogates, and also best interest are explored each time.
Thank you. I'm seeing a lot of thank you for an excellent presentation. I want to thank everyone for all the emoji love you've shown our speakers. And here's our contact information. And once again, we will be sending you this PowerPoint presentation after our summit ends tomorrow. Please fill out our evaluation and check out our website for any additional questions or forms that you might need. I think.
Thank you, everybody.
Thank
All right.
you.
It's really great questions. Thank you so much for tuning in today.
Enjoy the rest of your afternoon, everyone.